I'm going to give it a moment as everyone shuffles into the Zoom. So. All right. Welcome, everyone. My name is Anna Hughes. I'm the Director of Trusts over with the ARC of Northern Virginia. It's an absolute pleasure to introduce Sophia Munson and Stephanie Fairs, as well as Kristen Hawthorne over from Munson Law. We're here today for a Financial Fitness Friday, and we're going to be discussing estate planning, trust plans, and all of that great information. And so we'll be taking questions at the end, and we are recording today's session, so just full disclosure. And then Sophia, I'll hand it over to you so that you can do some introductions and we'll get started.
Wonderful. Well, Anna, thank you so much for having us today. We're excited to be here and always to join the ARC in literally anything you do. And so first, I want to just say hello to everybody and to introduce myself. I'm Sophia Munson, and my husband and I run the Munson Law Firm. I have now been doing special needs planning for too many years to actually admit right now. But really, one of the things I love about the ARC is I wanted to find a way to give back and speak with families, especially knowing how few resources there are out there for so many of us, and think to myself, how can I get involved in the conversation? How can I share some information? And so today we're doing kind of the Financial Fitness Friday piece. You're going to see my son heading off to school 2 hours late in just a minute. But in general, what today is about is talking a bit about estate, how it can help protect your family, whether or not that's with a special needs trust, working with the ARC, kind of the basics. Right now, we have about 6 people in this room, and so I would love to encourage questions or getting involved. If you're the type of person who likes to just write a question, that's completely fine. If you want to raise your hand or give a shout out, we really believe that the most useful conversations are ones in which everybody can actually participate. And so I am going to go ahead and get to the next stage, which is who here has actually done any estate planning? Crap. Now, one of the things I'm trying to see, Anna, do you know how I can see the attendees? I see all of us, which is lovely.
So you should be able to select participants on the bottom ribbon.
Oh, got
and
it.
it'll populate panelists, which is our 4 names, and then the 6. And then I believe you can put information into the chat or into Q&A. I don't know if participants have the ability to unmute themselves, only because it's the webinar format. But webinar chat and the Q&A, which is also on the bottom ribbon under more, if you have it condensed, is another opportunity to interact.
Got it. Okay. In general, so I'll just keep talking and feel free to pop in if you have something to say. When we talk about estate planning, we're thinking about a couple of different pieces. The first is, what are we planning for? And that can be what your assets are, what your debts are, what you have that you would want to give away, whether that's your stuff. I've seen people who really care about where the ugly snowman goes. Those are all important conversations. And so typically our analysis when we are thinking about estate planning is, what are we looking to plan for? If you have debts, are they the type of debts that are just yours? Are they owned with your spouse as well? What does that mean or look like for you? And so that's the first piece. The second piece is, who are we planning for? And typically, if you are coming through the ARC, you have somebody special who you're probably planning for. And so that might mean that somebody is receiving what we call means tested government benefits. We need to make sure that they couldn't receive too much money, because it would actually impair their access to government benefits. I will tell you that there are ways around that. I have seen folks with special needs be a recipient of different assets, but it's a real pain. It is not a fun or an easy thing to do. And so by taking a moment here to think ahead and plan, to me, it's the best possible love letter, the best gift you can give your family, to take the time where we stand at this moment and say, hey, let's think ahead. Let's consider now, how are we going to make this something that protects my family members? And so typically where we start with our estate plan is deciding what type of tool we want to use for the majority of the plan. There are two kind of the most common tools that estate planners in Virginia are going to use. Unless you have millions and millions of dollars, then definitely talk to me. That's a little bit different. But right now, as long as you're under more than 13 million per person, combined for $27 million for a married couple, we're not too worried about taxes. We're not too worried about, very complex planning. And so usually we are thinking about, is it a will or a trust? And I'm talking about a family trust here, not a special needs trust. I will get to that soon, but right now, just a family trust. First, when we look at a will is the right tool for a family with pretty basic assets and or pretty straightforward beneficiaries. A will does not avoid what's called probate. Probate is the process by which the court gets to approve distribution of assets. And so if you have a lot of assets, having them tied up in court for 6 months, a year, sometimes more than a year, that is a real hassle. If you have young or vulnerable beneficiaries, having probate, again, is a big problem. And so typically, if I'm looking at a will, the only time I think it makes sense is if we say, hey, I've literally got like one house, couple of accounts, and all of my beneficiaries are competent adults. Or one benefit here is if you have gone through the ARC and created a pooled special needs trust for your beneficiary, that to me is almost the equivalent of a responsible adult because you've said, okay, it's all going to the ARC. And so the will has some good benefits to it. It's simple, easy to read. I think people are generally more comfortable with some of the terms in that document. And so for the right client, a will by itself is a good tool. In Virginia, we have something called a transfer on death deed as well. And that actually is a way to leave your property, your real property, directly to a beneficiary. Again, we can have some issues here because if you give your property directly to a 6-year-old, crazy story, the 6-year-old can actually inherit it, even though that's insane to me, but they can't enter into a contract. So now we have a 6-year-old who actually owns the property, but they can't sell the property. They can't rent it out. Basically, you have just created a very difficult administrative piece. And so we want to think again, who would be the recipient of any of your real property? And so when I'm thinking about a will, I'm looking for straightforward, to the point. A trust, a family trust, is often a better tool when we are looking at somebody with reasonably large assets. I'm not talking about the 13 million, but I would say, kind of 500 to 1 million plus for kind of a typical middle upper class or upper class family in terms of assets. That's usually going to be the size that makes sense. A trust, I am biased because this is what I do all day. And so I can absolutely tell you a trust is much easier to administer after somebody becomes incapacitated or passes away. The way a trust works is first the lawyer set up basically a legal fiction. They say, here are some pieces of paper, and they say that you created a trust and also that you are the initial trustee of your trust. When we say that, we mean that you're still in charge of all of your assets. During your life, as long as you have capacity, we're not taking away any of those abilities. And so what we are doing instead is saying, hey, but if I became incapacitated or if I passed away, here's who would step into my shoes actually as the owner of that asset. And so I'm going to use an example because usually when, again, I'm looking at the trust, I start going asset by asset. For your home, we actually prepare something called a deed of gift. For a lot of people, their home is one of their biggest assets. And so we are saying, your home, now I'm putting it into the trust. It's still you as the trustee. And so you still have full power and authority over that asset. You can still sell it, rent it out, and sadly, you are still responsible for all taxes on it. So this is not a tax avoidance scheme. But what it means is you have said, now the trust owns my property. And if anything ever happened to me, my successor trustee is actually already the owner of the property. It is so easy that people are sometimes a little bit confused about it because there's no court. If something happened to you, that person you trust, that could be a friend or a family member, they just step into your shoes. And now they are able to oversee the trust and that property for your benefit. Most importantly for all of you, that means the benefit of your beneficiary. And so in particular, if we have a family member with special needs, often parents or siblings will talk to me and say, you know what, Alan really needs to remain in the house. That's where he's most comfortable. And so we can build that into the trust, regardless of whether or not Alan is receiving means tested government benefits. We can say, hey, listen, we are going to create a residence trust, and Alan can stay there for as long as he wants to and as long as it's healthy for him. And so that's a great way that we can use that real estate and be more flexible with it. For a lot of your other assets, things like life insurance, retirement accounts, and so on, what you're going to do is have the trust be a beneficiary of that. And so for something like life insurance, the trust isn't going to own it because it's based on you. You purchased it, it's your life. But you can say, if I passed, the trust would be a beneficiary. And that's the level where we also talk about, giving to your spouse if you're married, do you want to do anything particular there? But in principle, we're thinking of the trust being a recipient of those assets if something happened to you. All of this leads to better organization. And so again, one of the reasons why I really like trusts is because they force you to take stock of some of your assets and to think, who is my beneficiary on this asset? And you would be surprised at how often I see people who are like, I know everything, I'm all set. And then they find that retirement account from 7 jobs ago, totally forgot about it. Worst case scenario, I see people who have assets with, the ex-spouse's name on them. They still inherit those if you still have their name on there. And so it's a really good practice to sort of go through and think about what you might want to do there. And then within the trust, there's a lot of flexibility, and what I love is privacy. Probate is public. Everybody knows what's in your will, who it's going to. And so if we're saying, hey, I've got a vulnerable beneficiary, that's where people start to come out of the woodwork and say, so sorry to hear about your loss. Did you know that I was owed money? And so to me, especially in today's day and age, I hate to acknowledge it, but I think we're all pretty used to seeing some scams out there. And so a trust does a much better job because whatever is in the trust is private. The only people who know it are going to be you, your trustee, and the people who you choose to tell. And so we have much better protection over younger beneficiaries, vulnerable beneficiaries. And also, if you want to give gifts, that is like cash gifts to different places, it's really nobody's business but your own. And so you might say, you know what, I want to give 50% to one sister and absolutely nothing to the other sister. Maybe you don't want to put that in a will because it will cause family drama, but a trust is a great place to do it. I have had a lot of people in today's political climate say, I'd like to give to a specific cause, and I don't really want my family to know that I support that cause. Again, a trust is a really good way to do that. And within the trust itself, you are naming your successor trustee. And as I mentioned earlier, this does not need to be a financial whiz. It does need to be somebody you trust. And so that can be a friend or a family member. And there also are what we call corporate trustees. Corporate trustees have a little bit more expertise. Technically, the ARC is a form of a corporate trustee. It's a nonprofit, and so they're the good kind of corporate trustee. But basically, they know exactly what they're doing. They run this type of trust all the time. They run the trust specifically for a beneficiary with special needs. But even for a family trust, we often deal with families who say, listen, like I don't have a friend or a family member who I think could really oversee my money. And so that leads us to think about, is there somebody else who can help? Biggest downside of corporate trustees is they cost more money. Biggest upside is they have a responsibility to be making you money. So if you pick Joe off the street, we have to think of a reasonable person standard. Joe might hire a financial advisor, but he's probably not a financial whiz. Whereas if we choose a corporate trustee, they really are expected to keep making money for the trust because that's what they're doing. It's also in their interest because of the cost involved. And so corporate trustees are a backup. Now, within the family trust, often with clients from the ARC, we talk about a special needs trust. A special needs trust, even though again we call it a trust, it's not the same as the family trust. The family trust, we're looking at, that probate avoidance, the privacy, and the flexibility that it allows. A special needs trust or a supplemental needs trust is a really special category of trust. It is built just around the beneficiary. And so if you have a family member who is receiving means-tested government benefits, we don't want to impair that access to benefits by giving the beneficiary money. Instead, we are going to say, I'm going to set up a special needs trust. And so I will share with you all, my son is on the spectrum. I hope that he does not need a supplemental needs trust, but honestly, as I'm sure many of us, I don't know. And so using him as an example, I would want to make sure that the funds could be used to supplement his life, but not take away from what the government is already going to pay for. And so that means the trust probably is not going to pay for medical care, for medicine. Those are all things that the government pays for. But I want to make sure that his room is decorated the way he wants it. He's got his comfy pillow. He can travel and go on vacations, and I can pay for his companion to go with him on all of those things. And so in doing a special needs trust, it is a way that I'm saying, for Chase, I really want to make sure that he is cared for in a very specific way and that he's not penalized for the fact that he received some money. And so typically when somebody comes to an attorney to set up a special needs trust, we build out a whole separate document that is just, Chase's special needs trust. If you are working with the ARC, which is a great option for many of you, they actually will help you set up the special needs trust. And they are what's called a pooled special needs trust. That means they have an awful lot of participants and they're able to sort of oversee all of it. Great thing with the ARC is access to resources. And one of the reasons why I tell people that, it's at least worth considering whether or not the ARC is the right place for you is an independent special needs trust. Your trustee is going to have to work a lot harder to find resources. They're probably going to end up partnering with the ARC in one way or another anyway. But in general, the ARC provides that pooled special needs trust versus an independent special needs trust that is just for your beneficiary. I'm going to pause for a second and say that there's also another option, which is I speak to clients all the time whose children or beneficiaries are not yet receiving government benefits, but they might, or it might be needed, or they would like to plan for that. And in those circumstances, we actually create what's called a springing supplemental needs trust. It says, hey, listen, right now they're not receiving this benefit, but if they were going to, this trust would spring into action. And so that's something that we often build into our family trust plan because, again, unfortunately, a lot of the things that I believe should qualify you for government benefits, at least right now, do not. And so that's a backup option. The next category is one where the beneficiary, unfortunately, is not likely to receive government benefits, but they're not able to make great financial decisions. For many of us who might have loved ones who have mental illness and things along those lines, again, even though I fully believe those should be deemed covered by the government, they are not and they're unlikely to be. And so we also build something into our family trust called beneficiaries under impairment. That means if our beneficiary, for whatever reason, wasn't in the right stage to manage their financial affairs, the trustee can actually hold their money in trust, even through their life, still pay for their care, still make sure that rent is paid and so on. But I know that for many of us, we look at our family members and we think, well, unfortunately, this isn't going to be something the government helps us with. We can still protect them. And a family trust does a really good job of allowing for that to occur. And so that is how we set up the trust itself. And as I said, you can probably tell by how much time I have spent on it. Typically, for most of us, we are thinking that a trust is going to be a good option. There is a price difference between setting up a trust and a will. I will tell you, whatever the price difference is and the cost of setting it up, it is made back usually multiple fold by not going through probate. And so I tend to say that a family trust looks more expensive on the front end, but absolutely, if we look at it in the long run, it's actually the cheaper option. It's just harder to see that when you're comparing it at the beginning. A family trust does come with a will, but it has a special name. It is called a pour-over will, and that is POUR. And I want you to imagine that it pours any asset that for whatever reason wasn't in the trust into the trust. You will say, we just put my house in the trust. We just named the trust as beneficiary of all my accounts. What are you talking about? There's almost no perfect estate. Stephanie and I have been doing this for a long time, and we've seen almost no perfect estates. And so usually somebody forgot something. There's something out there that, the beneficiary was not updated, and the pour over will makes sure everything gets to the trust. And so it doesn't avoid probate, but it makes sure we've got everything where it needs to go. For all of you, probably the more important thing is guardianship. The guardian is responsible for the physical care and well-being of the beneficiary. And often here I'm both writing about minor children and sometimes also about an adult child that a parent has custody of. The guardian and the trustee can be the same person, but they don't have to be. And often, especially when we have a beneficiary with higher needs, they're not going to be. And so maybe you say, my friend Alice would really be the one who's able to take care of this beneficiary properly. She knows him, she knows how to care for him. But, day-to-day finances, they're not her thing. And so that's why there's often a mix of those two. If we just have minor children, it's actually a bit more common to have it be the same person. And again, you might say, well, my sister, in my case, my sister has 2 kids. She's kind of juggling all these things anyway. She might as well add 2 more kids and some more finances to her plate. Lucky girl. And so we are building all of that in for her. The last thing in your will is naming executor. An executor is another fancy word, but it really just means the person who is going to be responsible for paying debts and taxes and moving everything to the trust. There's so much overlap between the role of executor and trustee that you might as well name the same person for both of those. But a pour over will is a much shorter document because we've got that privacy element. It just says everything to the trust. And along with this, for a trust, we also think about all of your stuff. And so this is for either a trust or a will. You probably have jewelry or art or family heirlooms or what have you. And in Virginia, there's a special document called a memorandum of tangible personal property. This is actually a place to write down a list where you can write specific items and who you want them to go to. Some people have nothing and they say, listen, that's just not my thing. But what's neat about this document is it's the only document you can continue to update whenever you want to. It only requires a signature and a date. Please do not write on your trust or your will because you can revoke them. But we have this rule and it says as long as you keep a list, your intent is clear, and you keep it with your other important documents, your trustee and your executor are going to go ahead and follow it first. And so for the vast majority of people we work with, either the will or a combination of the will and the trust and the memorandum of tangible personal property are going to go ahead and take care of distribution of all of their assets. And again, when we have a beneficiary that is receiving means-tested government benefits, we either want to set up a current special needs trust or make sure it's directed to a pooled special needs trust or potentially a springing special needs trust. The next documents we're going to talk about, to me, are actually the most important documents in estate planning. And if you take nothing else away from this conversation today, I would love for you to go ahead and ask anybody you know over the age of 18 if they have these documents. So here we are looking at a power of attorney. A power of attorney allows somebody else to adult on your behalf. That means fight with your insurance company, open your mail, pay your bills, deal with your life. Being a power of attorney, and I say this from experience, is not fun. It is probably the least fun task, but it does have to be done because the power of attorney means you are still alive, but for whatever reason, you're not able to oversee your affairs yourself. And so I know this is crazy for everybody, but if you're over the age of 18 and if you are competent, a power of attorney is a really important document. Again, often when we are working with clients with special needs, there are different degrees, and I'm sure y'all have seen some, cooperative decision making and so on. Sometimes the power of attorney can be used even in place of guardianship or conservatorship. The next document is going to be an advanced medical directive, and this document does 2 things. First, it says who would make medical decisions for you if you could not make them yourself. Second, it tells somebody what those decisions might be. And so end-of-life care, funeral arrangements, organ donation. This is the one that people like to think about the least. But I will also tell you that to me, I often hear clients say it gives them the most peace of mind to just have talked about it, put down their wishes, and then hopefully they can put it in a box and not think about it. But again, for me, I often am lucky to have clients who are thinking about this for themselves, but they don't realize that it also applies to their children or to their parents or to their siblings. I care a lot about all these documents, but your care during your life, your child's care during their life, that's really most important of all. Everything else can be worked out. It's not always fun, but it can be worked out. If you do not have a power of attorney and medical directive, it is a very involved, expensive, and difficult process to be formally named as guardian of a loved one. And so everything we can do to avoid that is going to be beneficial. And so those are kind of the primary documents that are part of a good estate plan. But I'm also going to encourage you all to really think about organizing, because the best documents in the world do not provide a roadmap for loved ones. And we have all experienced too many family members who come in and they've got a huge binder. They're very proud of the binder. And I'm like, where are the retirement accounts? And nobody knows, or only one spouse knows. And so, along with estate planning, as you're looking at your financial fitness, I encourage you to spend some time looking at where your different assets are and figuring out, how would you write that down? People will have different techniques. We specifically give our clients certain, worksheets to use, but they're not, the only way to do it. Really, the question is, how do we get into these different things? I encourage all of my clients to think about a life drill, which Kirsten is cringing right now because she hates that name. But the concept is, something that everybody could do this weekend is say, if something happened to me, could somebody get into my house? Once they get into my house, do they know where my important documents are? Once they find those documents and can actually get into the lockbox, they know the code, they know where the key is, can they get into my phone and my computer? Just those 4 steps can make a huge difference for loved ones. And again, you do not need fancy estate documents to take those steps, or to ask your mom or dad if they can take those steps for you. And so I would love for everybody to consider doing that and sharing that with others. The other thing is, and I'm in North Carolina day to day, and so I have recently seen directly some of the damage done here through the floods up in Western North Carolina. And I'm sure if you watch the news, you all have seen what's going on in California. And so one of the things we've been asked or thinking about is, how do I store my documents safely? First, we are learning that there's no absolute answer to that, right? Because nothing is completely safe anymore. But with that in mind, I do recommend at this time considering a fireproof lockbox in your home with a go bag in it. One of the documents that Stephanie and I are actually working on right now, unfortunately, is a family emergency plan. So what could you just get and grab and go out the door? Because moving a heavy lockbox is not necessarily an easy thing to do. The banks and attorneys' offices and so on were not completely free of the floods and of the fires. And so with that in mind, I think that truly probably having everything on the cloud remains the safest way. But these are all different ways that we can continue to make it as safe as possible. And so again, when we talk to clients about estate planning, and especially when we're talking to clients about special needs planning, these are all the considerations and the things that we look at. And so I'm going to pause for a minute here and let my colleague Stephanie cover anything that I may have forgotten. And then I think Kirsten is going to open it up for a few minutes for questions. And so Stephanie, anything that I didn't cover with that?
No, I mean, I think that again, the most important thing is that you are looking at, like Sophia said, you want to make sure that you're thinking about potential contingencies and looking at all your people, all your loved ones, how you want them to benefit from your estate, but also how you want to protect them. And so, I agree, these can be really difficult conversations. And it most of the time though, even if it's hard to start this process, like Sophia said, when people have gotten these documents signed, it is a sigh of relief. And they just, not that it's the only time, we still recommend that every 5 to 10 years, you're reevaluating your situation because things may change, you may move, beneficiaries or agents may change. So there is a lot of things that we want to consider potentially making, changes down the road. But once you get that foundational plan in place, that is the hard work. And that is the biggest step you can take to protecting you, your loved ones, and, anybody else who is dependent on you for support.
I agree. And again, Stephanie, that gave me a minute to think. Another question that comes up a lot is, do I need to change my documents all the time? And one of the things I hear a lot is, well, I moved here from New Jersey, and so my documents aren't valid anymore. I want you to know that your documents are valid in all 50 states, at least right now. And so with that said, if you move to a different place, it's absolutely worth checking in with an attorney and seeing, a move is kind of a big life event. And so maybe that means other things. Maybe you're changing your trustee because now you live much closer to cousin L than you did before. But in principle, your documents are valid in all 50 states, and they do not have to be completely redone when you move to a new jurisdiction. But what we're looking for in terms of updates are kind of a time frame, and Stephanie got that time frame. But again, other big life changes, other big things that occur where, it's a birth, death, divorce, big changes to somebody where you're in a room with an attorney saying, wonder if this impacts my, estate planning. But in general, the hardest part, and the part that I think that we work with clients the most on, is kind of that starting place. And my personal recommendation is to give yourself a short period of time. So when we work with clients, we're a little bit, I hate to use the word mean, we're scheduled. We make sure that, from kind of the initial meeting, you have 2 weeks to get back some decisions on your fiduciary form. Then you have your draft review and signing scheduled from the outset. Because I have seen so often that even people who get the process started, they will then sort of be like, making these decisions is hard. And so we do try to keep people moving along. And if and when you are meeting with attorneys and saying, hey, listen, can you help us with estate planning? I would ask that question, how do you kind of keep us on track? Because I will tell you, actually, I'm very proud because I just wrapped up a 2-year-old client yesterday. And that's not the norm, but it does happen. And life and illness and so on certainly, take priority over other things. But in general, if you are working with a good attorney, it should be something like kind of a 4 to 8 week time frame to just have it taken care of. This is not something that needs to cover you for the next 6 months of 2025.
And we try our best to guide you through those decisions. I know sometimes people don't want to get started because they're like, I don't know. There are a lot of blanks. I don't know who to choose in this role. Should they be the same person? Like Sophia mentioned earlier, some cases that makes sense. Some case it doesn't make sense to have, the same person in multiple roles. And so that's again one thing that we often tell our clients, hey, blanks on the form are okay. Just come in to see us. Let's talk through it. We can help you with those decisions. And any attorney who is kind of used to dealing with these, we're all familiar with how difficult that can be.
And I would also add that one of the things we try to do are have resources. And so folks who come to us, again, especially if you have a special needs beneficiary, sometimes they'll ask me questions where I'm like, I'm not your person for this question. I do estate planning. I don't know the answer to that. One of the great things with ARC in particular is they have so many wonderful people in their network. And through them, we have met some great folks who can help with different things. So you say, I have no idea who a corporate trustee is who could help with special needs beneficiaries. Well, we have a list of some of those people who we've seen in action and we trust. And again, when we are looking at kind of what your concerns are, maybe you don't even know that there's an answer. With most attorneys who are in this role, if they've been doing it for a long enough period of time, they should be able to say, I know that that's a hard decision for you, and here's how we would help you answer it. And at least it gives you a start rather than saying, I still have no idea. Okay, so I'm going to pause for questions, and Kirsten, I think we got a couple of them if you want to go ahead and read those.
I'm also just going to chime in, Sophia. I did find the way of unmuting participants. So if anyone wants to ask their question aloud, just raise your hand. As Sophia mentioned earlier, you can react. If you click that button, it gives you the raise the hand option, and we can go through the line and unmute as appropriate. So I figured we'll get through these 3, but wanted to ask, or 4, and then add that you can ask your question aloud.
Wonderful. Thank you.
Of course.
So I'm just looking to see if anyone put their hand up, and I don't see it. So I'm going to go ahead and read the question. The first one is, are there fees for maintaining the real estate in the trust? Example, leaving the house to be used by a beneficiary who manages the property when I pass.
So 2 parts to that. In principle, no, as in there are no like attorney fees for leaving the home in the trust, right? Once you put the home in the trust, it's not like you have to pay your lender or anybody in particular a yearly fee. With that said, if we set up what's called a residence in trust, you say, I would like Anthony to be able to live in the trust for the rest of his life. Typically, I would suggest that we give some money to that specific residential trust to pay for upkeep. Honestly, it's kind of interesting because you can choose what you want to pay for. So some people say, I want to pay for everything. I want Anthony to just stay there. I want to pay whatever remains of the mortgage. I want to pay for the upkeep and maintenance, taxes, electricity, and so on. Some people say, you know what, I don't want to pay for all those things. He can stay in the home, but he needs to keep paying for whatever is in there. And so that's up to you. There's not technically a quote yearly fee of it. The trustee can take compensation if they're overseeing it, but it's not something that is outside of that. And so in general, I would say the answer is no, but if you choose to put money in, the money can be used towards the care of the house.
Great. Okay, the next question we have is, for presently competent adults, do you recommend a springing POA? Any special
No.
considerations re-springing POA?
I hate spring powers of attorney and we don't do them. So spring power of attorney, just to explain it for those who don't know, means that the power of attorney only becomes effective upon certification of incapacity. And you can choose kind of who would sign off on the incapacity. It can be one doctor or two or a psychiatrist. In general, and again, I say this from personal experience, the line at which somebody is incapacitated is very tough to find for a lot of people. And the line in which they might be easily influenced or taken advantage of, even though a doctor would not say this person is incompetent, but suddenly you see, they come home from the grocery store, real story, and say, there was somebody who really needed money for the King of Africa, and what, I wanted to give them money. Is that incapacitated? It's difficult. And so in general, I say if you trust this individual enough to name them as your power of attorney, you have to understand that they have a legal responsibility to you. They must serve as, quote, your fiduciary. That means they can only do things for your benefit and on your behalf. And so in principle, I would say, I would much rather that my family members are able to make this decision more easily versus needing to go through two doctors and arguments about whether or not I'm really incapacitated. I trust them to make the right decisions and to help me do the same.
And there's a second part to that question. My 24-year-old daughter has autism, receives SSI. My husband and I are legal guardians. She has currently unfunded special needs trust. Her grandmother passed away and will name her daughter, not her special needs trust, as a beneficiary in the will for about $20,000. How can I transfer the funds my daughter will inherit to her special needs trust or elsewhere without jeopardizing her SSI benefits?
So that's a little bit more of an in-depth question that I would say typically I would want to, meet with you directly to talk about it. But in general, it's going to involve some work. And so I'm actually pulling it up. The will names your daughter directly as a beneficiary. Right. Yeah. So you want to get that. I'm not giving legal advice, but in principle, when one receives funds, we either need to look at moving it into a first party special needs trust or spending it down very quickly. There's no way to transfer it to a third party special needs trust. And so personally, I would talk to Anna about something like this. I would talk to a financial advisor named Courtney Haycoop that we work with a lot and works with the ARC a lot. But in principle, once the document has occurred, once the transfer has occurred, it now belongs to your daughter. And so there's no way to avoid it unless it is basically taken care of very quickly. And anything to add to that one?
I mean, I was gonna share, so first party trust, we call it a self-funded, it's interchangeable. The only other consideration I could throw out there is if you have an ABLE account, there might be a way to put some money aside, but there is a cap to how much you can contribute to an ABLE account, so it wouldn't be able to accept the full 20,000.
Yep. But
that seems like a great segue into a next question about ABLE accounts. So another participant asked, my son has an ABLE account. Would he need a will to cover distribution of these assets? Also, if he becomes incapacitated, would he need a power of attorney regarding this as well?
So if your son has capacity, your son should have a power of attorney and should probably have a will. And so if your son is competent to make his own decisions, yes. Able accounts are pretty particular. And again, I don't want to get outside of my wheelhouse, but in principle, they can only be used for very specific purposes. And I don't know, and I think it can even depend on the account, if your son continues to like have control. It usually they don't have control. The whole purpose is that the beneficiary doesn't have control over them. And so my guess is, in general, if your son is over the age of 18 and has capacity, I would absolutely want to get him a power of attorney and medical directive at a minimum to make sure that you can help with whatever he needs for that asset.
And the other thing I'll add to that is that again, if he's able to make those decisions now, you want to make sure to go get those in place before such time if he were not able to make them. Because once he can no longer make those decisions, you can't get that power of attorney anymore, or the healthcare power of attorney for him. So if he does currently have capacity, even if in a basic form, you want to make sure that you get those documents in place for him before such time that he wouldn't have capacity, because then it's too late.
Yep.
Great. I'm going to skip down to one and then come back to another one that kind of goes back to something we talked about. And so the next question would be, can you please explain again how a family trust and a special needs trust work together?
So a family trust is actually about your care. So it's about the care of the people creating it. And it usually, the funds can be used for sort of whatever your care is. We're not limiting anything on it. And so, for example, if my husband and I were setting up a trust, it's really, we're the first choice beneficiaries of the trust. As long as we are living, the trust is for us. And then if we were to pass, it goes to our children. But while we might limit the way they can receive funds to health, education, maintenance, and support until they reach certain ages, I don't really have any bigger constraints on it. And so a family trust, I would say, is more, the benefits of a family trust, as we talked about, are not necessarily that it meets government criteria. And so when we get to a supplemental needs trust, that actually has very strict rules about what's included in it. And that says this trust is only for Jane. Nobody else is a beneficiary. This is a trust only for Jane. And so versus family, where we've just said, we're caring for beneficiaries during their life and then after death, this is only Jane's trust. I am going to fill this document with rules about how Jane's money can be used and can't be used. And so again, unlike a family trust where it's basically like health, education, maintenance, support, sometimes even any purpose, Jane's trust is going to say this cannot be used to impair her access to government benefits. And so here are the types of things that the trustee could use it for, and here are the types of things that the trustee could not use it for. And so, one of the things that's difficult right now is we're talking about theoretical. I think it's a lot easier if you, look at and read the difference. But in principle, a supplemental needs trust is going to be limited to a single beneficiary. And it's all going to be about that beneficiary and the rules that are required by the government to make sure that any of the inheritance is not treated as a countable resource. I hope that helps.
And then the last one is a little bit more specific, so I'll read that. We're exploring a TOD deed for our real estate. What issues should we consider in naming our disabled daughter's special needs trust versus our daughter? Our second adult daughter is neurotypical, is the standby legal guardian for her special needs sister. We want our TOD deed to name our neurotypical adult daughter and our special needs daughter in the special needs trust.
I would not do that. So again, can't get into legal advice, but a transfer on death deed is a very blunt instrument. And so again, I would certainly look at or talk about it, but to me, that's a perfect example of where a family trust would do a better job of kind of considering the nuances there of, you want to make sure that the trust ultimately, often a special needs trust is not going to hold, quote, real estate. It might hold the value of it or something along those lines, but it's not actually going to have real estate. And Anna, with the ARC, do you all hold real estate?
We do. That
Yeah.
is something that we do. Granted, there's a questionnaire that we obtain first to make sure that it's appropriate for the special needs trust to hold it.
Yep.
And then we would have a memorandum of understanding to accept the property into the
Yep.
trust.
And my other problem with it, and I'm interested in your thoughts here, is with the transfer on death deed, you have to give 50% to each of those beneficiaries. So they don't even own all of it. So in your case, let's just imagine that they were using a trust through the ARC, and you were told that you're going to receive 50% of the value of a property. Does that change your analysis?
It would. We would
Yeah.
have a conversation with KeyBank, but at that point, it's not showing that it's for the sole benefit of the beneficiary because it's split.
Yeah, exactly right. And so anyway, to the person asking the question, in principle, I would say that a transfer on death deed to me is only a good way to do it if you have just a few beneficiaries and if you're really comfortable with them just literally receiving it. And so competent adult children, and I would go with no more than 2 personally, because it becomes messy after that, preferably just 1. And so I would say that setting up a family trust to own the property and then to better direct things over to the special needs trust, to me, would be a better answer than using a transfer on death deed.
Great. And we have another question. I have full guardianship of my 22-year-old son. Does he also need a power of attorney?
So that can depend. And again, there are parts of kind of the collaborative decision making, but in principle, if you have full guardianship, you have already gone through the process. You have already done all the things needed. And so no, and he probably would not be deemed competent to understand the contract required for a power of attorney.
Okay, and I think we have one more. In terms of power of attorney, does the non-springing power of attorney replace the principal's legal capacity?
Can you say that to me one more time?
Yep, I can read. This lovely person has lots of examples, but I thought I would kind of keep it general so it might apply to others. But it says about powers of attorney, does the non-springing POA replace the principal's legal capacity? Or does the power of attorney and the principal have legal capacity regarding the principal's assets?
The power of attorney. So let's imagine I have a power of attorney right now that names my husband as my agent. That does not mean that my husband can be like, ooh, fun. I'm going to go into all of her accounts. I'm going to, take her money, right? Because again, he's got a fiduciary responsibility to me. He's named, but the only way he could act, let's imagine what I like to think about is I am off on a cruise somewhere. I have no access to internet because that's the type of cruise I want to take. And something happens to a car that's just in my name. So my husband's stuck back at home with our 2 children in January weather. Something happens to my car. He would be able to serve as my power of attorney in that circumstance because I'm not there. I can't handle it. And the car is only in my name. And so that's an example of where, even though I have capacity, it just doesn't make sense for me to do it. And so it's important to understand that your agent is able to serve to support you, but it needs to be at least like reasonable that you have asked them, or it would be implied that you want them to handle it because you couldn't, because I have no access to internet where I am, and now there's a problem with my car.
The other thing that I'll add to that, and it's, without getting into too many specifics and to getting specific legal advice, because I don't know the full scenario in your case, in the questioner's case, but when you are acting as the power of attorney agent for somebody who has documented incapacity, and there is a question of who gets determined what happens to those assets and who does not, as that agent, you do have the ability to say, hey, I'm the one that this person, that the principal has said, I want you to act on my behalf if I can't make those decisions, so that in the future, if I make decisions that are not advised, you really are the one who's supposed to be making those decisions. And so you do have authority to step in, and make decisions on that person's behalf, even when it comes to, physical assets. Okay. The one complication is, obviously, when somebody is, particularly when they're in the early stages of incapacity, or there are, early stages of cognitive decline, it can be a testy situation. And we have dealt with a lot of clients where it's difficult because they're the one who's entitled to act, but the principal is not fully recognizing the powers that they gave you 5 or 10 years ago. And so it can be a difficult scenario, but yes, you do have the authority to do that. And if the principal is making decisions, letting people have access to their assets without you there and causing problems, those are the kinds of things that you may want to speak to somebody about what you're able to do to protect them. and
Yep.
to protect them from coming into to the principal's house, taking things, or if they're selling things they're not supposed to, because as that agent, particularly if it is someone where you are the now acting attorney, or excuse me, agent under that power of attorney, you do have that ability to step in on behalf of that principal and block people from doing things that they shouldn't be doing, because they are probably taking advantage in certain circumstances. But we just can't speak to it specifically. But I think that is something you may want to consider talking to somebody more about your specific situation.
Hey, and I think unless somebody has a new, oh, yeah, we got one more.
There was one
Um,
earlier too, I think, Kirsten, there was a question about springing SNTs earlier at about 10:40. At 10.
Yeah, I think Sophia answered that, but I'm not sure.
Oh,
If you
maybe not.
wanna
I thought it was
if
about
you
the
wanna,
springing
No, I
POA.
don't think I did actually.
We
Okay.
talked about the springing powers of attorney, but not the springing SNT and how that would work.
Apologies. Yep. If you wanna address that, that would be great.
Yeah, sure. So springing S&T, the way I do it is it's quite literally an article, a piece of the puzzle within my family trust. And it says, hey, listen, in the event that any of my beneficiaries was receiving means tested government benefits at the time when they are entitled to a distribution, this trust would suddenly come into play. So it doesn't say at the top of it, it doesn't say Jane's trust, because we don't know that Jane will be the one who needs it. It is instead much more open-ended, and it says if any of the beneficiaries named in this family trust had this need, these are the terms of the supplemental needs trust that would then exist at that time. Unless a client tells me specifically that they want if we have a supplemental needs trust, I want to have this as the trustee. Usually it's the same as the trustee of the trust as a whole. And so again, within the trust, we allow for options for the trustee to choose either a successor, a co-trustee, or even to just resign and say, hey, listen, like so-and-so can take over this piece. And so even though technically my kind of standard way of drafting it does not name or change to a different trustee, certainly, based on the client, that would be doable. And because it is a separate trust or would become a separate trust, what is very cool is it can be what you want. And so I can say, if this supplemental needs trust came into play, this would be a different trustee. Or we can just say, hey, listen, it would still be Joe. And so truly it could be customized. Depending on how customized we're getting, that's sometimes part of where I'm saying, is this still springing? Is this something we just want to set up at this point? Because the concept of a spring should be something where I don't know that the beneficiary either is already or is pretty likely to receive. And so often what I'm talking to clients about is, they're providing for their children and for potential grandchildren. And especially grandchildren, I hate to say it, but life can happen and we don't know what will happen there. And so that's kind of the right fit for a spring supplemental needs trust. If we are really sure kind of who we're thinking of, who we have in mind, who we want as the trustee, that gets me more and more to maybe we should just set up a separate trust for the individual that you have in mind.
Okay. I think that was all the questions. Stephanie is answering one that looked like it needed a little more clarification via the chat. But other than that, unless any of our audience members have another question, it looks like we've covered everything that has been in the chat.
So first, I'll just say thank you again so much, Anna, for pulling this together. For everybody who joined, thank you so much for joining. I hope that this was helpful information for all of you. And just so you know, we are partnering with the ARC to do what's called Ask the Attorney. It's kind of a 15-minute session where you can throw your more specific questions at me, talk about your family. Still can't give legal advice, but at least we can brainstorm a little bit more specifically for you. And then, of course, if you ever just want to reach out to us for a full consultation, anybody who comes to us through this webinar is going to be a complimentary consultation. So usually we do charge for certain consultations, but anybody here just reference, hey, I was on the webinar, and it will be complimentary for you. And you would speak with me a little bit more in depth about your family needs. But either way, I hope that this was a helpful learning experience, and I hope that you all have a very happy Friday. Anything else from us, Anna?
No, I was just going to say thank you so much, all three of you, for joining and sharing this helpful information. And in reference to the Ask the Attorney, every month we send out our special needs trust newsletter, and that's where we put we plug in, the upcoming dates, and if you're interested, who you get in contact with, and if the slots are filled, we'll keep you on a wait list for the next opportunity.
Yep.
So thank you, everyone, and you all have a wonderful day.
You
Thank
too.
you.
Thanks
Thanks for
so
having
much.
us.
Everyone.
Take
Of
care.
course, take care.